All right, good evening, everyone. Yesterday, 90 degrees, low humidity, a perfect day for the beach. Tonight, a great evening for the beach. However, we're here to learn about the beach, which I think is just as cool. So, my name is Paul Destin. I'm the director here of the Wells National Estuarine Research Reserve, commonly known as the Wells Reserve at Logholm. We're one of 29 estuarine research reserves around the nation, dedicated to the advancement of knowledge through science and education, and to the conservation of natural resources. As our name implies, we're all about where rivers meet the sea. But we're also about where people meet the sea. Thus the reason many of our programs focus on people and nature, and in this particular instance, people and ownership and access to the wonderful coastal lands of Maine. 5 years ago, we embarked on a program, a multi-year effort. We didn't know at the time it would be multi-year, but multi-year public information effort to educate people about ownership and access issues in the state of Maine, because we are unique. We've had debates, we've had seminars, we've had just good informational discussions over the course of the 5 years. We've had a Maine Supreme Court Justice in this room, we've had advocates for the Moody Beach landowners, and we've had advocates who argue against the particular cases. So we're delighted that we're part of this educational effort here. After all, York County, Maine is the epicenter of issues surrounding coastal ownership and access. I look at it, it's like these tectonic plates here. Moody Beach and Wells Beach and Goose Rocks Beach, and they converge, they collide, they separate, and the tremors are felt throughout the rest of Maine. They truly are, in a legal and a real practical sense. As part of that effort, I want to just point to this publication. We produced a number of publications here with our colleagues at Maine Sea Grant and the Coastal Program. This is one we did 2 years ago. We tried to explain in layman's terms all of these issues surrounding Maine shoreline. Who owns it? Who gets to use it? We've also have had a number of speakers come, and we're delighted this evening, speaking of epicenter, to have Professor Orlando Delogu here with us this evening. Professor Delogu has been at the center of issues surrounding coastal access and beach ownership and public trust rights for well over 30 years. I began reading some of his materials over 30 years ago, about 30 years ago, so show you how old I am. And I was delighted in a couple of years when we started to put this series on that Orlando, I believe, Professor Delogu was at most of them. Professor Delogu is a prolific writer. He spent 51 years at the University of Maine Law School, both teaching and doing research. He has a long record of public service and engagement in land use, property, and environmental law, and public policy. He's even traveled overseas to consult with other governments on land issues and environmental issues. He's participated in cases dealing with environmental and land use issues, as well as cases in testing the limits of governmental tax and spending power. Just in the last 10 years alone, he's published 75 pieces. He's also written a number of what's called amicus briefs in support of, let's say, on the opposite side of the Moody Beach decision. He supported the more expansive published trust rights in the intertidal zone, as well as, perhaps the intertidal zone should really belong to the people of Maine. Most recently, just a couple months ago, he published a book called Maine's Beaches Are Public Property. I think you know where Professor Delogu stands on this issue. And we're delighted that he is here today to present some of the main tenets in his book, as he lays out the case of why the Maine Supreme Judicial Court erred almost 30 years ago in the Moody Beach cases. He may also share some of his insights in some of the more recent cases that have come down, as well as some to come. So the format tonight is going to be Professor Delogu is going to present for 30 to 40 minutes or so, and then he's going to open it up for questions. So I'm delighted to turn it all over to Professor Delogu.
Thank you, Paul. I'm used to standing in front of classes, so I don't think you'll have trouble hearing me. They've also wired me up for the preservation of whatever I have to say. If you can't hear, I'll certainly speak up. Just raise your hands in the back. What I want to do, though, is lay out really a lot of ideas that proceed through the book. The book is, in my view, a summation of arguments that I've made in fragmented forms, or as this particular issue arose in either a legislative or a judicial setting, and then 3 or 4 years later a collateral issue arose, and then I could expand this idea, and then as that proceeded through a series of cases, the most important of which, of course, were the 2 Moody Beach cases, I found that a lot of my views on public rights, public ownership, public control of intertidal lands was a bit here and a bit there and a bit there, and I wanted to pull it together in a more systematic way in an A to Z context where the lion's share of the arguments I've made over a very long period of time are in one volume, and I tried to write it at 2 levels. The text is op-ed prose. It is readable. It is a minimal of legalese, and there are a handful of citations from courts that I think are important, but I didn't want it to be perceived as a sort of law review article, too wonkish and too talking over some people's heads. The footnotes, on the other hand, for those of you that have a sort of wonkish soul, whether you're a lawyer or not, burrow in more fully to language of statutes and language of other cases, and certainly should be read, can be read by legislators and lawyers and environmental organizations and individual citizens if they really want to get the full argument for the public rights that I believe exist. And they're not just rights to use the beach beyond fishing, fowling, and navigation. That goes without saying in my mind. I think the law courts, the limiting of public use rights to fishing and fowling and navigation just doesn't pass even a straight face test. Even in the era of the Colonial Ordinance, 1647, the most significant public use was neither fishing or fowling or navigation, but lateral passage. It's the only way you could get from point A to point B, particularly in areas of Massachusetts that were not yet a state, parts of what are now New Hampshire and Maine. You go a mile inland, there was no Route 1 or 95. There were Indians that would take your scalp for you if you weren't along where the settlements were, and the settlements tended to be at the mouths of rivers or where natural harbors were, and there was some utilization of intertidal land for wharfing out purposes. They didn't need to be told to do that, but that's where they landed. That's where nature had provided anchorage and access to the intertidal zone, and then the first settlements were 100 yards up above the dry sand area, and more about that later. But the fact is, in the era in which the Colonial Ordinance, which was said to have alienated all of the intertidal lands in the whole of Massachusetts for wharfing out purposes, the Massachusetts legislators never adhered to that. There were settings in which they did, where commercial wharfing out was being undertaken, the Gloucesters and the New Bedfords and Boston Harbors and a handful of other places, as in Maine, where Portland and Arundel and Cape Porpoise and other areas became the focal points of settlement. But interestingly enough, and I think this is one of the chapters in the book, it's not one of the early chapters, it's one of the later ones, but the legislative instrumentalities in Massachusetts that began with the Massachusetts Bay Colony and ultimately became the state of Massachusetts and the Massachusetts legislature in all of the settlements in Maine. And the book recites 4 major areas in which settlements occurred: York, Wells, the area around the Royal River, and Portland. All of these settlements, the original settlers were granted title if they would settle upon the land and become the foothold group around which community would ultimately develop and emerge. From mean high landward, there isn't a single setting in which the basic instruments for settlement, clothing proprietors with grants of upland, in which the intertidal zone was alienated, in which the intertidal zone was not reserved for the public, held in trust by these original settlers in what was the fledgling governmental instruments. And then as these fledgling instruments ultimately became towns, then those rights were then ceded to the town, and ultimately the town became a unit within the state, and the state becomes the holder of the common lands, the lands that were not given to individual proprietors, not given to settlers, not given to the most immediate upland owner, but were reserved for the public. And I think that's an important chapter that we in Maine need to be aware of. My book doesn't go back and try to unravel the emergence of what is a unique legal doctrine in the state of Massachusetts. We need to understand that Massachusetts alone, among all of the coastal states in the nation, of which there are some 20, and if you include the Great Lakes, I think the number goes up to 23, the beds of navigable and tidal waters are held by the state in trust for the people. Massachusetts alone purports to have fashioned this singular posture in which all of the intertidal land, pursuant to a judicial interpretation of the Colonial Ordinance, has been alienated to the upland owner. I want you to understand that the arguments I make in the book, therefore, are not some egghead law professor trying to strike out to the North Pole, differentiating the ideas that he's putting forward from everyone else in the nation. I'm saying everyone else in the nation has arrived at a more sensible conclusion with respect to intertidal lands long before Massachusetts, and belatedly Maine in the Bell cases, has said we think we grew out of Massachusetts, and Massachusetts intertidal land law ought to be followed, and in certain areas it was followed because there was wharfing out and we needed to fill some intertidal land. And in order to encourage that wharfing out, that particular upland owner, but that's a far different proposition from all intertidal land in the whole state being given over to the upland owner. That didn't need to happen in Massachusetts, but they've settled on that. It didn't need to happen in Maine, and yet we let it happen to us in the Bell cases. Let me take a step, 2 steps, 3 steps backward, having sort of begun in the middle. I want you to understand that 1,500 years ago, we're not talking about Maine here. We're talking about areas around the Mediterranean. And we're talking about codes that were fashioned by Justinian and by Roman emperors. They felt there were a certain class of things that were incapable of private ownership. Understand that phrase, incapable of private ownership. And their examples were the air, the high seas, the oceans, the intertidal zone, the hydrologic cycle. No one owns the rain. If you capture a bit of rainwater from your roof into a barrel and you water it, you own that. You've captured it. Wild animals, birds whose natural habitat may traverse 10,000 miles in an annual cycle. No one owns wild animals, wild birds, fish in the ocean, unless you capture one. You catch the fish, you own the fish. You shoot the bird, you own the bird. Well, assuming you shot the bird illegally in today's world. But you see my point. Things that were seen as incapable of private ownership because they were so necessary to achieve legitimate public purposes. The intertidal land is the interface between the way commerce and peoples moved globally, using ships, river systems, the Great Lakes in our part of the world, seas in other parts of the world that had outlets to larger bodies of water, a Black Sea into a Mediterranean, a Red Sea into, you see my point, the Indian Ocean. That transitional area that we call intertidal land, on occasions, in particular settings, often at the mouth of rivers, but not exclusively, but often at the mouth of rivers, lent itself to commercial settlements, to commercial trade, to the need to build warehouses and piers that would give access to navigable water more than brief periods in the day when the tide was at its highest. So wharfing out 100 feet or 300 feet or 500 feet, and of course in some of the wharves we have today, even greater distances, facilitated marine commerce. And it's very clear that by the time we went from Justinian and Roman codes, that English common law doctrines embraced those very principles. The intertidal waters for a marine nation, England was one of the first marine power nations for hundreds of years. Its settlements were in Asia. Its settlements were in Africa. Its settlements were in other parts of Europe. Its settlements ultimately were here. The Massachusetts Bay Colony and colonies along the eastern seaboard of the United States almost all had their roots, save for a handful, that had Spanish roots in some of the southern states, South Carolina, and parts of Alabama, and so forth. But you see my point. English common law embraced Roman law. And the important point to remember is that when English common law gave way, it gave way to a new nation, a revolution. The colonies broke away from England, but that didn't mean they lost their common sense. They didn't abandon the principles of intertidal land, of necessity, being held by the state in trust for the public. That's why most of the states share the arguments that I make in the book, that that is the received law that the 13 colonies, now the 13 states, the 13 original states, and then the question that arose was, and how do we deal with the new states that will be founded from the combination either of purchase or conquest or discovery? That's how nations grew. You did one of those three things. We said we discovered the New World. Well, there were a lot of people here, so I don't know who discovered it, but we like to think we discovered it. But whether we discovered it or we conquered it in a revolution where we broke away from England, or we purchased it like the Louisiana Purchase and the purchase of Alaska from the Russians, well, I bet they regret that today, don't they? But you see my point. We kept the sensible body of law that said the intertidal lands, because we were still maritime people. We were still of necessity. There weren't trucks and trains and planes. There weren't highways. We thought it was a big deal when we finally got a railroad across the country, but that was in the mid-1800s, mid to late 1800s. So it was water that was important. It was seagoing. It was, and you needed to own the intertidal land if you were a nation, if you were a government. And lots of people had access. There were people who lived along rivers, people who lived along the Great Lakes, people who lived along the eastern seaboard, lived along the Gulf Coast, and ultimately lived along the whole stretch from Washington through Oregon and California, and all of those lands. And now the question that arose is how are we going to treat these new states? If these 13 original colonies accepted English law, well, there's a doctrine that was framed within the Constitution, the federal Constitution, not the Maine Constitution, that said that all the states needed to be on an equal footing with one another. There was not going to be any second-class states. There were not going to be any states that had more while other states had less. And what did that mean? Well, let me read you a word or two from about a half a dozen cases, literally a word or two. As early as 1842, that's a few years after Maine's statehood. I'll come back to that. In 1842, a case came out of New Jersey, and it's the highest court, or this is the Supreme. It was first in the highest court of New Jersey. I'm not going to read that to you, although it says something similar. It went to the Supreme Court. Here's what the U.S. Supreme Court said. When the Revolution took place, the people of each state became themselves sovereign in that character hold the absolute right to all their navigable waters and the soils under them. 1845, case came out of Alabama. Such state, Alabama in this case, shall be admitted into the Congress of the United States on an equal footing with the original states in all respects whatsoever. Then to Alabama, along the navigable waters and the soils under them, in controversy in this case. 1891, Knight versus the United States. It is a settled rule of law in this court that the absolute property in and dominion and sovereignty over the soils under the tidewaters in the original states were reserved to the several states, and the new states, since admitted, have the same rights. Well, 1947, United States versus California. I'm going to stop reading these cases because there's a half a dozen or more United States Supreme Court cases ignored by the Bell courts that make it unambiguously clear that when we became a state, and we're no different from Alabama, we're not a second-class citizen, we had the right to fashion our own intertidal land law, and we began with the state having ownership of all intertidal lands, and if any intertidal lands were going to be relinquished for wharfing out purposes, it had to be pursuant to legislative enactments of the state permitting that, allowing that transfer of title from the state to the immediate upland owner who is actually engaged in the filling of intertidal land for marine commerce purposes, which purposes we regarded as economically valuable and meeting a public benefit test and justify the alien. But when we're talking about wharfing out purposes, we're talking about 2 or 3% of the total intertidal land in the entire state. And then you have to ask, well, what about the rest of it? Well, if it isn't suitable, first of all, for marine commerce purposes, if it hasn't been filled, then the title to that land remains in the state, in trust for the public, and the public is limited only by the legislative determination of what uses are prudent, what uses are sensible. Some states allow you to drive an automobile along the beach. In Maine, we were gracious enough at one point to allow, when we thought we owned the beach, I might add, before the Bell cases declared otherwise, we allowed the Wright brothers to fly their damn plane on the beach of Maine and landed and take it up. States have allowed larger or smaller quantities of intertidal land to be filled. Some states as much as 2, 3, 4, 5%. Some states have used the filling of intertidal lands to a greater degree to facilitate aquaculture activities. We're doing a little of that in parts of Maine. You see my point. The intertidal law of a state, in terms of the permitted uses, almost all of the states have long ago done what the law court in Bell 2 said was not permissible, characterized it as a taking. Well, I've studied taking law till it's coming out both ears, and in my view, their characterization of the expansion of permitted uses to include recreation and walking along the beach, which is the equivalent of what used to be, of necessity, lateral passage. We don't need to get from Wells to Ogunquit and down by walking along the beach now. We have roads, we have highways, we can get there. But today, recreational activities are almost as important as wharfing out activities. Probably not in Portland Harbor, but certainly down along York County coastline and other parts of the state. And indeed, once you start looking at Maine, what you find is that there's little enclaves of beach. I did some work for Chebeague Island a few years ago, and boy, those Chebeague Island people love that island. And what they love on that island, among other things, is that there's about 300 yards of wonderful sand beach on the backside of Chebeague. And they like to think they own it. And they do, in my view. But the Upland Owners along the coasts of Maine are given the law as it now stands, where we have saddled ourselves, erroneously in my view, needlessly in my view, with Massachusetts law. It calls in question not simply the ownership issue, but what's the scope of use rights, because the Bell II Court went right back to the Colonial Ordinance and said, well, all they mentioned was fishing, fowling, and navigation, so that's all you have. I think that's a misreading of the Colonial Ordinance. Colonial Ordinance was never thought to be an itemization of exclusive uses, the only permitted uses. You can't find the phrase wharfing out in the Colonial Ordinance. You can't find the phrase only these uses in the Colonial Ordinance. The Colonial Ordinance was drafted by Boston and New Gloucester fishermen who had to build piers and had to fill land, and I think the court's interpretation that it alienated all the land as opposed to those small parcels of land suitable for wharfing out and necessary for marine commerce. It's the difference between an outright grant of all the intertidal land in a state or what's referred to in law as a license to fill land suitable for marine commerce with the permission of the state who holds the title to it, and they'll alienate that discrete parcel of intertidal land to the upland owner who's ready to make an investment. Call it what you will. It's an economic investment by a landowner who is fortuitously located on one hand and has the capital resources on the other that he's going to engage in marine commerce, and he's willing to sink his money into the pier and the wharf and the storage and the other support facilities necessary in historic and in modern marine commerce, but only if he has a certainty of title to the upland, which presumably he owns already, to the intertidal land, which he doesn't own, and maybe, if it's a big enough operation, he needs to be into the submerged land. Can the state alienate some of its submerged land? It can, on the same basis. Can it give it all away? It can. There's an interesting chapter in the book, and I'm going to stop and throw it open to questions in about 2 more minutes. I'll end with this chapter. It's called the Illinois Central Case. There was a period of time in about the 1880s, 1890s, when Chicago was busting out all over. It was the big city in the Midwest. It had a huge hinterland where we had fashioned the passage through the Great Lakes so it could participate from what was the middle of the country in global trade. The Illinois Central Railroad was the big railroad people in that era, in that part of the world, and they said, well, we're willing to work with the legislature, and we're going to build piers and warehouses, and we're going to broaden out this whole idea of marine commerce. And if you look at a map, you'll see how much hinterland there was around a historic Chicago. It stretched for hundreds of miles of rich farmland and timberlands in upper Michigan and Minnesota and Wisconsin, and corn and cattle and all of the bounty of those states then and today. And the Illinois legislature gave the Illinois Central Railroad a grant of all the bed of Chicago Harbor and said, go to it. And Illinois Central began. And they built some important facilities. But about 4 years later, the Illinois legislature realized that we kind of went much further than we needed to go here, and they repealed the grant to the Illinois Central Railroad of all the land in Chicago Harbor, and they said, we'll grant you in the future discrete additional parcels beyond where you've already built. That's done, that's history. We're repealing the grant of all the land in Chicago Harbor, and the Illinois Central Railroad people said, well, you can't do that. You gave it to us, it's ours. I mean, a gift is a gift, it's done deal. And the Supreme Court of the United States said it's not a done deal. Can't be a done deal. Property held by government in trust for the public cannot be simply in toto alienated by government. They characterized the original grant as either void on its face or voidable. Void or voidable. And they said the legislature stands ready to give you title to additional parcels after examining your plans for further marine development in appropriate settings, but that's going to leave the larger share of Chicago Harbor in the public's hands. And they characterized that as a taking. Same argument we saw being made in the Bell cases in the law court. The Supreme Court of the United States said, not a taking at all. You're not deprived of anything that your original corporate charter gave you. Indeed, you benefited from the original grant already. You will benefit from future grants. These grants have been made to you at minimal or no cost to you, and so you will have the economic return that your investment in marine commerce gives rise to, but in order to accomplish that, you don't need and have no right to the whole of the bed of Chicago Harbor, but you do have title to discrete portions. They characterized it again as a license, not a wholesale alienation, which they characterized as void or voidable. They made one other important point. This is the Supreme Court of the United States speaking. Their last point was, oh, by the way, a legislature is never shorn of its power to re-examine yesterday's law and expand it or narrow it in the public interest as today's sitting legislature believes is necessary and appropriate. In other words, the legislature that followed the legislative body that granted it all to Illinois Central, an excessive grant, more than they could possibly use or would ever need, was repealed by a legislature that was willing to say, we want you to develop the marine potential of Chicago Harbor. We encourage you to develop it. We'll work with you. We will grant you beyond the land you've already filled additional beds that may necessarily be filled in succeeding iterations of expansion of Chicago Harbor commerce. You're not at any economic loss. You stand to make a great deal of money, and the lion's share of Chicago Harbor will remain in the hands of government and trust for the public. A law court in Maine, before the Bell cases, was asked the question of whether an amendment to Maine's Submerged Land Act, which was sought by, interestingly enough, marine commercial interests, mainly in the Portland area, where they were unsure of their title to intertidal land, where they had already filled it, in some instances with permission from the legislature, in other instances without permission. But there was still more activity going on. For those of you old enough to remember, I look around the room, that includes one or two of you at least. There was P.D. Merrill's activity, and Bath Iron Works was talking about a dry dock facility, and there was talk of a container ship to rail to truck and so forth. There were things happening in Portland, but that private money wasn't going to be put on the table unless they were certain they owned the intertidal land. And the legislature passed a piece of legislation that said that we could confirm title to actually fill intertidal land areas anywhere in Maine. It was not just limited to Portland Harbor. And that would have done the same thing I've already said. It would have allowed 1 or 2 or 3% of the intertidal land in Maine to be alienated for purposes of wharfing out activities. We passed legislation that allowed the long-term lease and subsequently the sale of intertidal lands in 1975. This confirmation of title amendment to the 75 Act was sustained in an opinion of the justices. And the interesting thing about the opinion of the justices, well, there were really 2 or 3 things. The opinion said, first of all, intertidal land can never be alienated by a court. Courts decide cases. Courts do not decide to give away all the intertidal land in a state. Second of all, the Supreme Court of the United States in Illinois Central, now this is the Maine law court speaking, the Supreme Court of the United States in Illinois Central said that all of Chicago Harbor couldn't be given away. Well, if all of Chicago Harbor can't be given away, you damn well can't give away all the intertidal land in the whole state of Maine. Now that just seems like common sense to me. And the last thing it said was, the legislature of Maine did a smart thing with the 1981 amendment. It said it would confirm title to intertidal lands that were actually filled for marine commerce. It avoided the mistakes that Illinois originally made. And then the law court gives me a wonderful line for my argument. It said, if the legislature had made the same mistakes that Illinois made and given it all away, it would have violated Maine's Constitution. Article 1, Section 1. Well, they didn't make the mistake that Illinois made. They confirmed the title to bed areas actually filled for marine commerce. And today, that legislation still stands. We can talk to an entrepreneur in Eastport or in Lubec or in Searsport or in Belfast or in Portland or in South Portland or down the coast. And if there's a proposal, there was one just a few years ago on Sears Island, some major development activity up in the Searsport area. We're open to that. There's some intertidal land. We've got a lot of intertidal land. A lot of public uses can be sustained on that intertidal land and on a handful of discretely defined areas where commercial activities are suitable and can usefully be engaged in as part of the economic wherewithal of the state of Maine. We can alienate those discrete parcels. That's the argument that the book makes. I think the Bell cases ignored Maine case law on separation of powers. They've overstated the powers of the courts. They've aggrandized to themselves the right to simply, without examining on their own, was the Colonial Ordinance itself correctly decided by Massachusetts courts? Did the Massachusetts Legislature ever embrace the Colonial Ordinance? The ordinance itself had a shelf life of less than 50 years. It was passed and it was repealed. Did any Massachusetts legislature ever adopt the Colonial Ordinance or some later version of it? Never. Never happened. Hasn't happened to this day. How then has Massachusetts developed the intertidal law it has? It simply acquiesced to a series of judicial decisions that really have their roots not in 1647 or 1690 or 1720 or in 1750 or in after the Revolution and after the Declaration of Independence in 1800. The first case that articulated and that said the Colonial Ordinance alienated all the land in Massachusetts, intertidal land, for wharfing out purposes was an 1810 case. And the second case that took that view by a very eminent jurist in Massachusetts, Judge Shaw, was in 1850. Judge Shaw, in his opinion, however, acknowledges the first two cases I read to you, Martin versus the lessee and the Alabama case. But he didn't adhere to them. He acknowledges them. He knows that the Supreme Court of the United States had held that the equal footing doctrine stood for the proposition that the original 13 states embraced English common law, that later states would have the same right to embrace English common law, and upon statehood, well, I'll stop. You see where this is going. The fact of the matter is, the law court, in two decisions, the first in 1986, the second in 1989, made a number of errors. I'm not here to question anyone's motives. I'm simply saying courts have erred. Courts are well-intentioned. Courts sometimes, though, get a bee in their bonnet, and they give us a law that is unsupportable. It's illogical, it makes no common sense, and in this case it deprives the public of Maine of the rights to utilize its own intertidal lands. I'll close with one last quote, and we'll take as many questions as you have, as I have the strength to stand up and repeat. Here's the case, interestingly enough, that came down right between the two Bell cases. I remember thinking when Phillips came down, we're going to win this. We are going to win this. The Phillips case involved Mississippi, and it involved some Spanish grants, not a colonial ordinance from Britain, but a Spanish grant. And it involved oil companies. At common law, the title and dominion and lands flowed by the tidewater were in the king for the benefit of the nation. Upon the American Revolution, these rights, charged with a like trust, were vested in the original states within their respective borders. Sound familiar? This is 1988 now. I'm not talking 1842 where this all began. In 1845, and 1890, and 1945. Here's 1988. Upon the American Revolution, these rights charged with a like trust were vested in the original states within their respective borders. The new states admitted into the Union since the adoption of the Constitution, have the same rights as the original states. I rest my case. Let's hear from some of you.
I understand you correctly that when Maine became a state,
Yeah.
it did not have any responsibility to carry over Massachusetts law.
None.
Maine could make its own aggregate, modified for the greater good of the people of Maine.
Absolutely. That's the essence of the equal footing doctrine. I mean,
Is there any,
go ahead, I'm sorry.
has this state legislature ever taken up the question to definitively rule on it so that we take it out of the judicial realm?
The short answer to that is not until 1975. 1975, and then you can call the Maine Legislature whatever you want to call them, lost sight of the ball, or that they thought they didn't need to because the language in these Supreme Court cases and the language of the equal footing doctrine seemed clear enough. We own it. When the 1981 amendment to the 1975 Act was 1975 Act allowed for the leasing and then ultimately the sale of discrete parcels of intertidal land. It was its primary focus was on agriculture at that point, but clearly its implications extended beyond agriculture, and it said people who need to use intertidal land can have title to it, but we're talking discrete parcels. The bottom line is the three times the legislature has addressed intertidal lands was the 75 Act for leasing and ultimately sale purposes, the 81 amendment to that act, which was a confirmation of title to people who, some with legislative approval, some without, had filled intertidal land primarily in the Portland Harbor area. They wanted that. They wanted certainty that they owned what they were purporting to want to expand marine commerce on. And the third piece of legislation was in 1986, where the legislature expanded the use rights beyond fishing, fowling, and navigation to include recreational activities and passage along the beach.
Forgive me for a moment. What was the 86 decision then?
The court characterized it as a taking, said you can't expand those use rights. They were
Oh, okay.
limited by the Colonial Ordinance. Yeah, my analogy that I have in the book on that is what the legislature did with respect to intertidal land is a little different from what towns from Maine to California and in every corner of Maine have done in the context of zoning laws. Uses are expanded in certain zoning enactments and amendments, and they're narrowed. As times change, we build an interstate. What was farmland and was limited to farming uses is now suitable for commercial purposes, so we expand the uses. The idea that every time there's a zoning or a refusal to zone, that someone can argue taking, if my land isn't zoned for maximum utilization of my sense of economic potential, I don't want to build just one house on every 5 acres. My goodness, I want to build one house on 1 acre or on half an acre. I'll make more money that way. Well, courts just look at you like, are you from Mars? I mean, now that isn't to say that some zoning doesn't overreach. And there have been some zoning provisions that are struck down they go too far. They rob the owner of the land of all economic potential and use. There was no robbing of the Illinois Central Railroad of economic potential and use. My God, they had a bundle of economic potential in the original act, and they had a bundle of potential going into the future. the Upland Owners in Maine who have filled intertidal land are in a dozen or 24 harbors, some larger and some smaller in the state of Maine, and the same could be said in the state of Massachusetts, have not had anything taken from them. They have had a windfall. They didn't pay anything for the Colonial Ordinance. The Colonial Ordinance wasn't a sale. There was no quid pro quo. The Colonial Ordinance was at best and most charitably characterized as a gift which said, if you wore foul, you will have title. That's how every state and the Supreme Court of the United States and the opinion of the justices in 1981 in Maine have said is a viable way to balance the competing interests of public rights in intertidal land and private rights in discrete areas of intertidal land where there's a real public benefit, and the largest public benefit may derive from such things as wharfing out, marine commerce. But in today's world, we're not even sure of that. An equally valuable public benefit may derive from seaweed harvesting, or it may derive from recreational activities. We may yet lose, under my interpretation of public ownership, we may yet lose another 0.5% or 1% of Maine's intertidal land for well-located agricultural or seaweed harvesting or new marine commerce or expanded marine commerce activities. But that would leave 95, 96, 97%, give or take, of intertidal land, including most of the beaches. There isn't a beach in Maine that you're going to fill significantly for marine commerce purposes. I'll stop. Yes, sir.
Is anybody trying to challenge at the United States Supreme Court?
Well, I devote, again, a chapter in the book to that, and I'm blunt. I think we're duty-bound to give the law court the first opportunity to correct its own errors. Indeed, there's a legal doctrine that says you have to exhaust your remedies. You have to try and deal with the situation closest to home that impinges on the public's rights. So I think we have to find a case or bring a case, and believe me, I've been working on this for the last several months. We may yet have a case, but if the law court won't either take up the issue of ownership, if the law court takes it up but adheres to the Bell cases, I would run, not walk, to the U.S. Supreme Court. Because the U.S. Supreme Court has been unequivocal for close to 200 years. I read you their holdings in a half a dozen cases, but I could have read you 12 holdings. Would that have convinced you even more? I don't know, at some point. The Supreme Court has said, I will read you one more. A 2007 case arising not with respect to coastal navigable waters, but inland larger navigable water arising in Montana, hardly a hotbed of liberal thought. The Supreme Court says the title consequences of the equal footing doctrine can be stated in summary form. Upon statehood, now he's talking in this case about Montana's statehood, the state gains title within its borders to the beds of waters then navigable or tidally influenced. Well, there isn't any waters in Montana that's tidally influenced, but there are navigable waters, and yet he's stating the broad rule. This is the Supreme Court, a unanimous Supreme Court of the United States. The answer to your question is, if we cannot get the law court to revisit the Bell cases, simply own up to the fact that Here's a rare instance. It doesn't happen every day. Fortunately, our courts are better than that. But here's a rare instance where it made a number of errors, not just one or two errors. It made several errors. It was fixated on the view that Maine grew out of Massachusetts. Maine is committed to receive and accept Massachusetts law. Devil take the hindmost. Well, in this case, the devil doesn't have to take the hindmost. We are a state that stands equal with Massachusetts. We are not a second-class citizen. We are not beholden to Massachusetts. We never were. Massachusetts can do what it chooses to do as long as Massachusetts citizens sit on their hands. That is their prerogative. They can cede the lion's share of their intertidal lands to upland owners, but we do not have to. We did not have to from 1820 when we became a state. The book gives you, and I will not read it, the Statehood Act. The Statehood Act makes it unambiguously clear that Maine entered the Union as the 23rd state on an equal footing with the original states and all of the states subsequently admitted to the Union. Read it for yourself. Go ahead.
Is there any instance of, I'm thinking now about sea level rise and damage, and have any individual owners ceded back their rights to the state because they don't want to clean it up or fix it, or?
Well, there may be. I won't say there are none. I'm told that in the Goose Rocks area there are a number of people who have ceded their intertidal lands that were deemed in question to the town prior to the most recent case. Just for the benefit of everyone in the room, the most recent turn of the screw on these issues in Maine is very favorable to arguments I've put on the table before you this evening. In the first Goose Rocks case that went to the highest court in our state, the law court, the law court held that the town did not acquire any rights either by custom or by long public use, by what's called prescription, by having done the thing for 20, 30, 40, 50, 75, 100 years. They simply said that was not demonstrated. Then it remanded the case back to the lower court and said, but there were questions raised with respect to the actual ownership of the intertidal lands. The upland owners all claimed they had title to that piece of intertidal zone that was seaward of their upland, the upland portion of their parcel. So the trial court had the case back in its lap to examine the questions of ownership, and it got to where I began this evening. It looked at the original documents of settlement in Kennebunkport, and it went right back to the founding of the towns in the Cape Porpoise and I don't know. I don't think that's quite right. The Cape Porpoise area, the Goose Rocks Beach area was the focus. That's where all the plaintiffs were. Goose Rocks Beach is a lovely beach. It's north of the north and east of the center of Kennebunkport. The fact of the matter is, when you looked at all those original documents, exactly what the research outlined in Chapter 9 of the book, consistent in Maine settlements, all of the original titles ran from mean high landward. Mean high landward, not mean high seaward. The sea was not included. It did not include. Knew they couldn't include the intertidal lands because there would have been no way to access the settlements. The settlements in Maine from literally Kittery up beyond Harpswell, all have their roots in activities that at the earliest begin in about the mid-1600s, but many of those settlements, the settlers came and the Indians drove them out. 20 years later, the settlers came, or some of the old ones, some of the new ones, the Indians drove them out. Most of the settlements in this part of York County and Cumberland County, the whole process of settlement stretched over a long period of time, 20, 30, 40, 50, 60 years in some instances, before the settlement had enough roots in the sense of having driven the Indians sufficiently to the interior and north that there was some level of security, but there was never a relinquishing. The court in the Goose Rocks case, the court decision that came down, what, a month ago now, 2 weeks ago, 3 weeks ago. I don't advise you to read it. It's 276 pages long. I want you to understand that the court was not flipping. The court was not shooting off the top of its head. It went through the individual deeds of all of the plaintiffs. It searched the town's documentation from the year one of the founding of that enclave of settlement. The fact of the matter is, in 22 of the 23 lots that were part of the Goose Rocks Beach case, it said the town has title. The town owns the intertidal land. That's what I've been saying. The town owns it. What was the 23rd lot where that was not said? It was the lot closest to the Little River, where there was a natural anchorage, where there was moorage, where there was some wharfing out activity, and where there may very well have been an alienation of intertidal land to facilitate the survival of that settlement. Whether the law court will acquiesce remains to be seen. Stay tuned. This gentleman.
First, thank you so much for your work on this. We really appreciate that. And I realize that it would go contrary to your views on this matter, but are you aware of anyone having contemplated, or have you contemplated using eminent domain to recover intertidal zones for public use?
Yeah, I wrote a piece on that after the Bell cases came down, and I licked my wounds and said, well, what do we do now? And I did a piece that was entitled, Buy the Beaches, They'll Never Be Cheaper. And it was a longish piece, and I diagrammed out one of the beaches and made the case that we ought to, it was a precursor, I'd like to think, of the legislation that ultimately became the Land for Maine's Future approach that we have taken for at least the last 25 or 30 years. Land for Maine's Future allows an agency of the state to acquire unique and singularly, in many cases, attractive or aesthetically pleasing properties. I certainly would have put the prime beach areas of the state. But to me, the issue shouldn't be limited to a discussion of beach areas. Beach areas are the obvious, where recreational uses are being pursued today in a variety of ways. But I want you to think at least 3 activities of much longer term potential where intertidal lands need to be held by the state. One is certainly recreational activities. The second is agricultural activities. The third is seaweed harvesting activities. And the fourth may very well be with global warming and the opening up of a passage from the Atlantic to the Pacific over the top instead of around the bottom. We are the state that is in the closest proximity to Europe. Eastern Canada is going like this. There are parts of Newfoundland that are visible today that have never been visible. as glacial areas recede, Newfoundland is green underneath all of that white. And the water is now open, not occasionally, but for a decade or so ago, a month a year, and now 2 or 3 months a year. And I think very shortly it may be open for half a year. There was a squib on TV within the last month that I watched where the ice road in northern Canada is threatened with no longer being a viable way of reaching remote settlements in northern Canada because of it's so intermittent and there's so much water interspersed with land area. The last thing that these people want is an 18-wheeler with ice in the middle of January or February. Anyhow, questions? Go ahead, sir.
I've done a lot of research on wells, and I've gone to wells and Kenny Bunk, which were all one. Sir Ferdinand Dodges, there's an agent from the king, gave him, well, from the Piscataqua River to, I believe, the Kennebec River, I think it was, the right to the land, but it ended up that he sent his agent, Thomas Dodges, over here to divide the land up here in Wells. And our land, when the Littlefield came, and the wheelwright and his friend, they granted about all, this is in the 1640s, all that land along the edge was granted, but it all went to the seawall.
Yeah.
So they didn't take the beach because they were using that as the road that you were talking about.
Yeah.
And they never, the town of Wells, then it went to the, they gave the officials of the town of Wells the right to grant the land. And it got granted, and they granted 12,000 acres about the last time, something like 1773. But they never went across the river with the grant. If you take the Webb River, you went up the Marsh. Now they granted the Marsh land down to the river, but no deed ever went across those rivers. And it didn't just go to Route 1 or to the high ground. Back as far as you went up the Webb Hand, up the Gunther River, up the Maryland River.
Some of it went miles.
Yes, it went to the end, I guess, to the marshes, you might say. But they did grant marsh land and budded it.
Yeah.
And we here in Wells granted the marsh land just from all the owners along Route 1, their land from about Buffalo Hill this way, all went down until they hit the Webb Hand River. And then they came the other side up, and you were talking about Massachusetts, because their law, they had one that cured them to something like the low water line. But all our land grants, the 1653, when they came down here and said you're going to be part of Massachusetts, all of our land grants had already been really along that coast and been given out already. So,
Go ahead.
so it really wasn't, it was already decided that, and from Moody Point to the end of the Gunther River, and this includes this case you're talking about, John Littlefield, I think Edmund had it first, but John Littlefield, his son, had it, and he owned all that land. Then he went to Joffre, got killed by Indians, and it went down through and got divided up through over the years. A guy named Tibbetts came here about 1900, and he bought from Moody Point all the land to the mouth of the river, except that the Perkinses had a strip where Carl Merrill's motel was in Jungle Beach. He could never got that, and the Perkinses still went there when I was a kid, still Perkinses there. But he got all that land. He went to the state of Maine and got a deed written. And it was the land, they were the people who were on the land use, giving away the land that hadn't been divided up Maine after they bought the rest of Maine in the 1850s or something. But he got a deed they gave him inland to the Gunford River and down to what they call the Gunford, cleaning up Stevens Brook, from Moody Point, all the way down to a Gunford, to the river, all that land, and the state of Maine gave it 12,000 acres or something of beach land. If I remember right, because I've read that deed, I've seen that deed. But this is where the state of Maine did this group. I don't think they probably should have. And the same thing happened with Eaton and Campbell on Well Creek. The same thing. They went and bought the heirs up. First, he bought all the original heirs out of the people that had it. But then they went to the state of Maine and he'd give them I don't know if they were trying to clear title or what they were trying to do. And the same thing went down here. And I know Hatch's gave some land down here near the mouth of the harbor. It ended up that the state of Maine said, we are making the exact same that Hatch gave, but Hatch's went to the seawall. They gave to the low water line. And somehow that has got to get cleared up, I would think, to solve that Moody Beach case. Somehow they got to overrule that, which we've been talking about. But somehow that's got to, I would think, have to be taken care of.
Well, I think the deeds that were fashioned in the original settlement of North Yarmouth, which today includes 6 towns, all the way up to Hartsville, Neck, but Freeport, North Yarmouth, Falmouth, Pownell, some now landlocked. But all of those original deeds, which really are rooted around the mouth of the Royal River, 103 deeds that I've looked at, in a piece of research I did for the town of Cumberland years ago, and it's alluded to in the book. They all begin at mean high and go landward. There are settings in which spurious deeds have cropped up. That's what the court in the Goose Rocks case, this lower court decision I just mentioned, without ascribing any evil intent to anyone, the court simply says it's axiomatic in property law that one can't sell what one doesn't own. And as a deed that originally went from a mean high or the seawall landward, in a later generation says, and including the intertidal zone as additional language. And then the next transfer says from the seawall, seaward to the intertidals, including the intertidal zone, and landward to wherever the dividing line was. That's just referred to in property law as a spurious deed. The town never relinquished it. You can write a deed. I can sell you the Brooklyn Bridge in a deed that looks wonderful. I don't own the Brooklyn Bridge, though, and no amount of appearance. If I use all the right language, if I sell it to you at a steep price or a bargain price, if I purport to do this or that, is ever going to validate your ownership in the Brooklyn Bridge, because it's a spurious deed. So, did that occur? And were there mistakes made? Of course there were. Some of the original deeds, settlers were driven off the land, and then their children, or maybe a different group of settlers, came back in and built upon the foundations of the town, and that happened 2 or 3. It seems to me that the thing that our law court has not appreciated is is the fact that we became a state in 1820. Upon statehood, we obtained title to all of the intertidal lands in the state of Maine. Upon the Revolution, British colonial grants and Spanish colonial grants and spurious deeds all went out the window. All were a nullity. The original 13 states agreed to bind themselves to English common law with respect to intertidal lands, where the king and parliament held title and trust for the public. That was the law of the land. Massachusetts was an outlier. Maine had not yet been formed. When we were formed on an equal footing with the original states. We had title. So what you have to find for each parcel of intertidal land that the upland owner claims title to is a valid, not a spurious, but a valid grant, not by a court, but by a legislature, the legislature of the state, for a public purpose. Marine commerce is included. The causeway to an island would probably be included. A bridge abutment between an island and would probably be included. And that will probably alienate 2 or 3 or 4% of all of the intertidal land in the state. The minute I say that, you got to flip the coin over. What that leaves is 96 or 97 or 98% of the intertidal land in the state is held by the public. It's held by you and me, and taxpayers from Kittery to Eastport. And it's held in, the title is in a formal sense in the state in trust for us, for the widest range of public uses that are permitted, again, by a state legislature. The court's position that the case law of Massachusetts needs to be acceded to, because no Massachusetts legislature reenacted the Colonial Ordinance, and no Maine legislature enacted the Colonial Ordinance, or a modern 1820 version of the Colonial Ordinance, and no legislature post-1820 enacted anything that purported to alienate all of the intertidal land in Maine. And I come back to the proposition of the Supreme Court of the United States. Any such alienation is void or voidable. And I come back to the language of Maine's highest court in 1981. If any legislature had made the same mistake as the Illinois legislature made originally, it would violate Maine's Constitution. And then they decided the James case within 6 months, and they said, in a Maine case, and this will be my last comment, my last quote of any sort, James versus the town of West Bath. Judge Watson speaking, he's still around. A consistent theme in Maine decisional law is the concept that Maine's tidal lands are held by the state in a public trust for the people of the state. This is a 1981 Maine case. This is barely 5 years before the first Moody Beach case, and 8 years before the second. In a time sense, the ink was barely dry on this, and the law court ignored it. I think this is untenable. I think we have a case to be made. I will make the case, or try to make the case. I will work with attorneys. I will work with the legislature. I will work with the Natural Resources Council of Maine, or the Audubon Society, or the Conservation Law Foundation. I will work with the Attorney General's office. I think the case needs to be brought. I think the Bell cases need to be re-examined. I think that if they are re-examined with eyes wide open, not with the idea that we somehow are trapped by Massachusetts law. We're not. With our eyes wide open, I think we will reverse the Bell cases, and I think it'll happen in my lifetime. I'm not a book peddler, but I did bring several copies of the book. trials for me to save a hell of a lot because I don't have to earn Tower Publishing's or Amazon's profit margin. And it's $25 and I'll stop at that. There also are some synopsis of the book. It's 4 or 5 pages long, 6 pages, I think. That's a free copy. It's on the table. I don't think we've run out. I've got a few more in my bag. But thanks for coming, people. You've been a great audience.